All right, so we are going to end it with natural law. We're going to talk about natural law for a couple of reasons. One, it is what the framers of the federal Constitution were thinking about, one of the things anyway, when they were planning our form of government. Natural law goes back all the way to Thomas Aquinas and Augustine and all that. It is an inalienable right. The Bill of Rights is a good example. It's full of natural rights. You have a right to life. You have a right to speak freely. You have a right to, well, it's not in the Bill of Rights, but eat a chocolate ice cream cone. You have the right to walk down the street wearing a plaid shirt. You know, you have all these rights that are inherent to you because you are a human being. And this is what, at least part of what the framers were thinking about. And because, and here's the state and local government connection, the federal Congress asked the states to come up with their own constitutions similar in nature to the federal one. This got transferred, this thought. The Illinois Constitution gives, not, it doesn't give us, but it states that we have a lot of the freedoms that are in the Federal Bill of Rights, speech, bearing arms, etc., etc. All right, so there's the connection. This is a philosophy, all right, as with all philosophical arguments. You can certainly poke holes in this, and it's all right if you do, if you email me with a question about it. I would love it if you did, because then I know you were actually watching this video and paying attention to what I was saying. So let's get going. This will certainly be on the final, or whatever the next test is, if I use this in future semesters other than the fall of 2022. All right. So, we end as we began, back in England. Thomas More was Henry VIII's chancellor. And what the chancellor, the office of the chancellor still exists in a fashion. But what the chancellor was doing back in that time was running the kingdom on behalf of the king. The king would say, Thomas More, I want X, Y, and Z done. Thomas would go out and execute it and say, by the king's authority, I want, you know, this is happening, that's happening, and the other thing is happening. So he was kind of the public face of the king. He would get around a little bit more. To avoid a copyright strike, I will just say these 3 links were active as of 8:45. Who knows with YouTube, but please watch these videos. 2 of them, the bottom 2, if I'm remembering correctly, I can't remember what I had for breakfast, but the bottom 2 anyway, link to a video of a clip of a movie I'm very fond of, A Man for All Seasons, where you can, after the lecture anyway, listen to and watch and identify the natural rights that are on display there that are being talked about. And another, just kind of the top one, I believe, lays the groundwork of who St. Thomas More was, and we'll explain more of that. So, he is a saint now, declared so by the Catholic Church. He was put on trial for treason. And it was a show trial. The king said his head's coming off. And back then, if Henry VIII said your head was coming off, there was nothing and no one who was going to come save you. So he was executed 3 days after. He knew he was going to lose because he knew Henry. He was a great friend of Henry VIII. He taught Henry VIII. He was his tutor for a time. And he helped, he helped him with his writings. He advised him very closely, even before I was king. So he and Henry VIII and Thomas More were friends. I can't imagine ever doing this to a friend, but, then again, I'm not the King of England. So he knew he was going to lose. His alleged and proven act of treason was silence. He refused to state affirmatively that Henry VIII was the head of the church instead of the Pope, and that Henry VIII was legally married to Anne Boleyn. He was prepared to give ground on that one, but why would it be such a big deal to Thomas More that he'd be prepared to die on the hill that Henry VIII wasn't the head of the church? Because if you're Catholic, even still today, the Pope is the person who's the head of God's church on earth. I hate to paint in generalizations about religions, but Catholics believed more back then than I think they do today, that the Pope was God's literal mouthpiece, and that the word of the Lord came through the body of the Pope. He was God's mouthpiece. He was walking around on earth. What the Pope said was what the Lord said, and what the Pope said to do was what the Lord wanted done. Now, I could not imagine having that kind of authority. Catholics still believe this. Some of the older school Catholics, some believe it less. It just depends. Feel free to send me emails correcting me one way or the other. I am not a Catholic, so I cannot state definitively what the position of the church is. But that was the crime that Thomas More committed. Henry VIII was not the head of the church because nature's law said it was the Pope. The Bible says, "For thou art Peter, and upon this rock I will build my church." Peter, one of Jesus' disciples, was made head of the church. There is the biblical authority for the papacy. Henry VIII couldn't be the head of the church because it was the Pope, as a successor of Peter. So he says at his show trial, "Some men say the earth is round and some say it is flat. If it is round, can the king's command flatten it? And if it is flat, can Parliament make it round?" So what's he really trying to say? He's stating, the obvious. He said Parliament, which is the British version of Congress, cannot make our Congress is our version of the British Parliament, cannot make a flat earth round, and Henry VIII could not make a round earth flat. That is, or should be, obvious. Again, don't know if it was to the people at the time. He's arguing that there are restraints on government, and that those restraints come from nature, the natural order of things. The king can't make a flat earth, a round earth flat. Just can't happen. Henry VIII was a very interesting man. You should look into him. You should read about him if you don't know about Henry VIII. But even him, in all his, let's just say, majesty, could not do it. There are restraints. You can't do some things. You can't take a person's life without cause. You can't invade someone's privacy for no reason if you're the government. You can't do these things. Why? It goes against the natural order. If you don't like your grade, it is wrong for you to come find me on campus and do something terrible to me. It is against nature. This argument's in no way novel. Plato made it, Augustine, Aristotle, John Locke, St. Thomas Aquinas, Thomas Jefferson was saying it, Justice Clarence Thomas in the modern day, MLK. And this really was one of the things, as I said at the beginning, that influenced our founding documents, this concept of the natural law. And if I didn't say it, this is Anne Boleyn. So there is the natural law. Some people call it the natural law tradition. The opposite of that is positivism. Now, just to save time, so this video isn't hours long, I'm just going to say there are, maybe half a dozen versions of positivism, 4 of natural law. Just to save time, again, to get a clearer picture of how our liberties are protected in the Constitution, we're going to cut these down to just 2. One definition of the natural law, one definition of positivism. These definitions will probably be on the final. Just saying. Natural law. Our rights are knowable by the exercise of reason. Now, what is reason? What is the definition of reason? That's up to you to decide. All humans exercising reason will come generally to the same conclusion about what's right and what's wrong. I think we can all come to the conclusion that just in general, murder's wrong. In general, robbing somebody's wrong. In general, stopping someone from speaking at an actual peaceful protest, probably wrong. Invading someone's home without a search warrant, if you're an authority figure, wrong. We're going to generally come to those conclusions. All humans exercising reason are going to be exercising the freedom that comes from within us. Since, for whatever reason, we have become the highest thing in the food chain. We're top dog on planet Earth. We have the ability to develop our personalities. We have the ability to speak as we wish. And I know we all have a friend or two who should be very grateful that they have that ability. Publish what we say. Negative rights are also rights. Not publish. Not speak as we wish. Not develop a personality. I don't know how you don't develop a personality, but that's beside the point. These all have their origins in the natural law tradition. That is Mr. Jefferson. Okay. There are 2 sources of natural law. Whatever one you believe in, that's what you believe. There's a belief in the Almighty, a belief in God, that there's a triune God, Father, Son, and Holy Ghost, that created us. And he shares his greatest asset with us. As he is perfectly free, we too are perfectly free. This is the religious argument. One doesn't have to believe in God at all in order to accept this argument. So there's just the basic concept of human dignity. We all share the same amount of human dignity, all of us, because we're the most important rational. And again, I'd use that word in a very general manner. Figures on the planet. And because we all have that importance and dignity, we ought to and should respect it in each other. And either theory is going to get you to the fact that our rights come from our humanity. The government did not give us our rights. The government did not give us our rights. I'll say it again. The government did not give us our rights. Notice in the Constitution how it's worded. The Constitution does not say Congress shall grant the freedom of speech. There are some countries where that's written. So Congress grants the freedom of speech. Congress, in theory, could take away the freedom of speech. Ours does not say that. Congress shall make no law abridging the freedom of speech. They recognized that that was a natural right. It was not theirs to give. It's neither theirs to take away. positivism. It comes from posit. You're articulating the law. Positivism, just very basic. The law is whatever the lawgiver says it is. As long as it's articulated, written down, ratified, law. No matter who the lawgiver is. Me, the mayor, the president, whoever. So Congress says that you can't give more than $2,300 to a political campaign. Okay, law. That's law. Congress passed it, went through both houses, the president signed it. Great. Suppose Congress wrote a law that interfered with a natural law, though, like the freedom of speech. If Congress said there was no more freedom of speech, or Congress changed Amendment 1 to say, Congress shall grant the citizens of the United States the freedom of speech. Would we still have it? That's a question for you to ponder. So this is just a chart in case you're a little, in case you like those sort of things. Natural law, it's based upon principles and truth. It's harmonized with, due to our knowledge and understanding. It's universal. It exists and applies anywhere in the universe, regardless of location. And it's immutable. It exists and applies for as long as the universe exists, or as long as humanity exists, or maybe not. Who knows? Man's law, it's based on constructs of the mind. We should not pay more than $2,300 into a political campaign. If I had $2,300, I would not be spending it on a political campaign, I tell you that. It's complied with due to fear of punishment. You pay your taxes or you go to jail. Which one do you want? And it differs with location based upon the whim of legislatures. What is the law in Illinois may not be the law in Indiana. What law is in Indiana might not be the same thing as what the law is in Idaho. It's moral relativism. It's what legislatures feel is right in Illinois, Indiana, Idaho. And it can change based on a changing morality. It's moral relativism. Morality, a lot of it, it changes just depending on the times. So I went through this already, really. So Congress shall make no law respecting an establishment of religion. So there shall be no state religion. This was to avoid something like the Church of England, which Henry VIII created, or prohibiting the free exercise thereof, or abridging the freedom of speech. Now, the most important word there is the, because it articulates the natural law tradition. As funny as that sounds, the is the most important word in that statement. Abridging the freedom of speech. It's a recognition that freedom of speech pre-existed really any government at all. As human beings, we have the right to say what we want to the government, or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. So the Declaration of Independence is another great example of the natural law tradition. Jefferson says in this document, our rights are inalienable. In case you didn't know what that meant, they cannot be separated from us. I have the freedom of speech in Alaska. I have the freedom of speech in Washington, D.C. Travels with me. Can't be separated. There are rights, though, in the Constitution that come from both natural law and the positivist tradition. And again, I'm a little concerned that this might be problematic if I went to this link, but it's the Declaration of Independence. Go on there and see if you can pick out a few natural rights. Bet you can. So we have the Bill of Rights. These are rights that are written down. You can defend yourself. You can publish. You can refuse to publish Again, as I say, negative rights are also natural rights. You can be left alone. You have a right to your property. You have the right not to be tortured. You have the right to not testify against yourself. Amendment 5. You have the right to speak. You have the right to keep silent. You have the right to keep troops out of your home. Amendment 3. These rights are posited. They're written down, ratified, and accepted in the first 8 amendments. There are also these are also very much natural rights that we see here. Now, why are natural rights posited? Why are they written down? The founders, the people who wrote the Constitution, felt that these rights were so essential to human happiness, to who we are, that they wanted to make it even more difficult for the government to ever interfere with them. We also have Amendment 9 that says just because we listed rights in the first 8 amendments doesn't mean that those are exhaustive. We have other rights, too numerous to ever list. Eating an ice cream cone, writing a letter to a friend, talking on your cell phone, not doing any of those things. And that was a very real fear at one of these sessions. Are some government in the future going to say that we only have the rights listed in Amendments 1 through 8? So when rights come from both camps, they fall into this third area called substantive due process, which is what we were just talking about. So human behavior is so integral to the happiness of the individual that we're going to make it that much more difficult for the government to interfere with that behavior. It's not impossible nowadays for the government to interfere, but it is more difficult. And if Jefferson was going to be taken literally, and he should have been. He wrote the Declaration of Independence. He was a founding father, and if you believe the Constitution at all means what it says, you have the right to the freedom of speech, to a speedy trial, to all these things. These rights are inalienable. They're part of us. They don't exist separately. They don't exist in a vacuum. Should they be interfered with? That's for you to decide. I'm not going to tell you. I'm not going to offer an opinion on that. Can you shout fire in a crowded theater? No, not really. You shouldn't do that. Maybe you talk to the owner. You say, owner, I would really like to shout fire in Theater 1. I want to see what people do. Okay, the owner says, yes, you can do this. The question becomes who has the property rights to that theater, or who is in charge where you want to do this. Now, would the owner probably face a penalty or be charged under some law? Yeah, more than likely. But in theory, you can do this. So Congress shall make no law abridging the freedom of speech. So after the 14th Amendment, Congress was taken to mean no government. So substitute no government for Congress. No government shall make a law abridging the freedom of speech. Federal, state, local, no one can tyrannize you. And just so we're very clear before we move on, I do not advocate shouting fire in a crowded theater. Do not do that. It is very wrong. You should not do that. You're going to get yourself into trouble if you do. Okay, moving on to substantive due process. What is it? How is it made harder for the government to interfere so there's a rational basis for a law? That's one element. Reducing the speed limit in front of an elementary school. Okay, maybe there was a near miss on 2 or 3 occasions, and a kid almost got hurt because a car was going way too fast. Okay, we go to the school board and say, hey, this has happened 3 times. We need to make the speed limit much, much lower. School board says, okay. They talk to the police department. The police department talks to whoever they need to talk to. The speed limit is lowered. All right, that's fine. That's a rational basis for a law. I think we could all agree that the safety of little children is important, and important enough to reduce the speed limit. Now, there's strict scrutiny, which is a harder basis that the government has to take for interfering with a natural law. Choosing a person to marry, your right to have children and raise them how you'd like. Those are two examples of what would fall under strict scrutiny. So this puts a much heavier burden on the government. They have to show, in this instance, a really compelling reason that it's trying to interfere with who you're going to marry or who you're going to have children with or who you're going to raise them with. If it's trying to interfere with that right, and that its interference is the least restrictive alternative available. Now, do they make the case? Regrettably, sometimes, yes. It's a very high bar. The judiciary sets a very high bar with cases like that. But the government can sometimes do it, but they have to pass the strict scrutiny test. So sometimes courts will call natural law a pre-political right. Why? They want to avoid sounding too religious. Again, these natural law rights, and I don't know if they're really rights, if they've been with us since the beginning. These rights were with us before any government. They're pre-political, so they exist before the politics of the land did. We had them in America before any colony was settled. The Native Americans had them. Everybody had them. If the states repealed the First Amendment, do we still have the freedom of speech? No, it really depends upon what theory you subscribe to. Positivism, no, because Congress says, no, we no longer have the freedom of speech. Natural law, absolutely, we still have it. It's not Congress's to take away. So really, what theory do you subscribe to? And where does this all leave us in the end, Because there is a way for the government to get into substantive due process. Unfortunately, natural rights are not inalienable. If the government has any way to attack freedom, it's going to do that. We all thought back in the day that the Patriot Act was not going to be around forever and a day. We were very wrong. Our individual rights, perhaps, depending on how you look at it, are declining in this country. We are still a basically free society. But for how long and under what conditions are maybe our children going to live, or their children? So is the primacy of the individual really still paramount? Someone once said, this isn't my quote, does the government work for us or do we work for the government? And that's really a question worthy of consideration, at least in my opinion. And that is the natural law. Thank you very, very much for listening.